Okay, I'm reading Gideon versus Wainwright. Judge Black delivered the opinion of the court. Petitioner was charged in a Florida state court with having broken and entered a pool room with intent to commit a misdemeanor. Right? And this offense is a felony under Florida law. Appearing in court without funds and without a lawyer, petitioner asked the court to appoint counsel for him, whereupon the following colloquy took place. The court. Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. The defendant, the United States Supreme Court, says I am entitled to be represented by counsel. Put to trial before a jury, Gideon conducted his defense about as well as could be expected from a layman. He made an opening statement to the jury, cross-examined the state witnesses, presented arguments in his own defense, declined to testify himself, and made a short argument emphasizing his innocence to the charge contained in the information filed in the case. The jury returned a verdict of guilty, and petitioner was sentenced to 5 years in a state prison. Later, petitioner unsuccessfully attacked his conviction and sentence in the state Supreme Court on the ground that the trial court's refusal to appoint counsel for him violated his constitutional rights. Since 1942, when Betts v. Brady was decided by a divided court, the problem of defendant's federal constitutional right to counsel in a state court has been a continuing source of controversy and litigation in both state and federal courts. To give this problem another review here, we grant certiorari and appoint counsel to represent petitioner. And appointed counsel to do that. So we accept Betts' assumption based as it was on our prior cases that a provision of the Bill of Rights, which is fundamental and essential to a fair trial, is made obligatory upon the states by the 14th Amendment. We think the court in Betts was wrong, however, in concluding that the 6th Amendment's guarantee of counsel is not one of these fundamental rights. 10 years before Betts, this court, after full consideration of all the historical data examined in Betts, had unequivocally declared that the right to the aid of counsel is of this fundamental character. Citing Powell, while the court at the close of his Powell opinion did by its language, as this court frequently does, limit its holdings to the particular facts and circumstances of that case, its conclusions about the fundamental nature of the right to counsel are unmistakable. The fact that, in deciding as it did that appointment of counsel is not a fundamental right essential to a fair trial, the Betts court made an abrupt break with its own well-considered precedents. In returning to these old precedents, sounder, we believe, than the new, we but restore the constitutional principle established to receive a fair system of justice. Not only these precedents, but also reason and reflection require us to recognize that in our adversary system of criminal justice, any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. This seems to us to be an obvious truth. Governments, both state and federal, quite properly spend vast sums of money to establish machinery to try defendants accused of crime. Lawyers to prosecute are everywhere deemed essential to protect the public's interests in an orderly society. Similarly, there are a few defendants charged with crime, few indeed, who fail to hire the best lawyers they can get to prepare and present their defenses. That government hires lawyers to prosecute and defendants who have money hire lawyers to defend are the strongest indications of the widespread belief that lawyers in criminal courts are necessities, not luxuries. The right of one charged with crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but as is in ours from the very beginning, our state and national constitutions and laws have laid great emphasis on procedural and substantive safeguards designed to assure fair trials before impartial tribunals in which every defendant stands equal before the law. This noble ideal cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist him. The court in Betts departed from the sound wisdom upon which the court's holding in Powell rested. Florida, supported by 2 other states, has asked that Betts v. Brady be left intact. 22 states, as friends of the court, argue that Betts was an anachronism when handed down and that it should now be overruled. We agree, reversed. Justice Clark concurring in the result. The Constitution makes no distinction between the capital and non-capital cases. The 14th Amendment requires due process of law for the deprival of liberty, just as for the deprival of life, and there cannot constitutionally be a difference in the quality of the process based merely upon the supposed difference in the sanction involved. How can the 14th Amendment tolerate a procedure which it condemns in capital cases on the grounds that deprival of liberty can be less onerous than deprival of life, a value judgment not universally accepted, or that only the latter deprival is irrevocable? Justice Harlan concurring. I agree that Betts should be overruled, but consider it entitled to a more respectful burial than it has been accorded, at least on the part of those of us who were not on the court when that case was decided. I cannot subscribe to the view that Betts presented an abrupt break with its own considered precedents. In Powell, this court declared that under the particular facts then there presented, the ignorance and illiteracy of the defendants, their youth, and circumstances of public hostility, and above all that, they stood a deadly peril in their lives. The state court had a duty to assign counsel to the trial as a necessary requisite of due process law. It is evident that these limiting facts were not added to the opinion as an afterthought. They were repeatedly emphasized and were clearly regarded as important to the result. So Gideon was retried with counsel and acquitted from the newspaper in 1964. There's one more page of the dissenting opinions. Thus, when this court, a decade later, decided Betts, it did no more than to admit the possible existence of special circumstances in non-capital as well as capital trials, as well as while at the same time to insist that such circumstances be known in order to establish a denial of due process. The right to appoint a counsel has been recognized as being considerably broader in federal prosecutions. See Johnson versus Zerbst. But to have imposed these requirements on the state would indeed have been an abrupt break with the almost immediate past. The declaration that the right to appoint counsel in state prosecutions, as established in Powell, was not limited to capital cases was in truth not a departure from, but an extension of existing precedent. The principle is declared in Powell and in Betts, however, had a troubled journey throughout the years that have followed the one case, and then the other. Even by the time the Betts decision, dictum in at least one of the court's opinions had indicated that there was an absolute right to the services of counsel in the trial of state capital cases. In non-capital cases, the special circumstances rule has continued to exist in form, while in substance it has been substantially and steadily eroded. In the first decade after Betts, there were cases in which the court found special circumstances to be lacking, but usually by a sharply divided vote. However, no such decision has been cited to us, and I have found none after 1950. At the same time, there have been not a few cases in which special circumstances were found in little or nothing more than the complexity of the legal questions presented, although those questions were often of only routine difficulty. The court has come to recognize, in other words, that the mere existence of a serious criminal charge constituted in itself special circumstances requiring the services of counsel at trial. In truth, the Betts rule is no longer a reality. This evolution, however, appears not to have been fully recognized by many state courts. In the instance charged with the frontline responsibility for the enforcement of constitutional rights, to continue a rule which is honored by the court only with lip service is not a healthy thing, and in the long run will do disservice to the federal system. The special circumstances rule has been formally abandoned in capital cases, and the time has now come when it should be similarly abandoned in non-capital cases, at least as to offenses which, as the one involved here, carry the possibility of a substantial prison sentence. Whether the rule should extend to all criminal cases need not now be decided. In what is done today, I do not understand the court to depart from the principles laid down in Palco or to embrace the concept that the 14th Amendment incorporates the 6th Amendment as such. On these premises, I join in the judgment of the court. So, and moving on to Alabama versus Shelton. But just checking to see how long that decision is. It looks like it'll need another recording.